What if we could stop UK politicians from pursuing policies that cause climate breakdown? What if we could use international criminal law to stop most countries in the world from causing climate breakdown? Well, the group Genocide Act Now thinks it has proven that we can use existing legislation to stop the key climate criminals. We don't need a new piece of legislation. We use existing legislation to prosecute genocide and crimes against humanity. In this video, we will explain the legislation and its implications. It is a little complicated, but I promise that you will find what you hear exciting. It has huge potential to change the trajectory we are on, and it also has implications for people who have engaged in climate protest. There is evidence provided here that you should consider using if you are charged in connection with a dynamic climate protest. First, let's go back to 2019.
In November 2019, 39 members of Genocide Act Now, CGAN, walked into police stations across the country, just like this one here at Charing Cross. They presented a dossier of evidence asking police to mount an investigation into genocide and crimes against humanity committed by named senior government ministers. This was connected to the policies that are driving climate breakdown, killing millions, driving tens of millions from their lands, and starting a process that is destroying low-lying island states. The dossier was detailed with a wide range of policies that either seek to increase greenhouse gas emissions, for example, aviation policies, or unnecessarily seeks to slow the pace of decarbonising the economy, for example, the refusal of mass home insulation programmes. The legislation that allows for the prosecution of genocide and crimes against humanity is in the Rome Statute for the International Criminal Court. This came into UK jurisdiction under the International Criminal Court Act 2001. So the question is, are the politicians that are causing climate breakdown guilty of such crimes? Here's John Fuller to explain more.
I'm John Fuller and I helped to form CGAN in 2015. The aim of the group was to establish if there was some legal mechanism to stop politicians from killing millions of people by their policies that are causing climate breakdown. The case we submitted to the police was allocated to SO15, the war crimes team in the Metropolitan Police. We explained that there were two concepts in law and were enshrined in international criminal law. Direct intent. This is, I hate you and your people and I'm going to kill you or drive you all away from your land. Oblique intent. This is, I want something and I know that people will be injured or killed if I pursue what I want, but I'm going to pursue it anyway. That's the position with climate breakdown. Politicians want to obtain the personal and economic benefits from burning fossil fuels and know that there will be appalling death and suffering caused, but they're determined to carry on anyway. Unless otherwise provided, a person shall be criminally responsible and held liable for punishment for a crime within the jurisdiction of the court only if the material elements are committed with intent and knowledge. 2. For the purposes of this article, a person has intent where A. In relation to conduct, that person means to engage in the conduct. B. In relation to a consequence, that person means to cause that consequence or is aware that it will occur in the ordinary course of events. 3. For the purposes of this article, knowledge means awareness that a circumstance exists or a consequence will occur in the ordinary course of events. Know and knowingly shall be construed accordingly. So Article 32b legislates for crimes of oblique intent. Politicians know that their policies are causing unprecedented suffering and death. Over 20 years ago, the accused had been warned by expert scientists that their policies would cause mass loss of life, immense suffering, and the displacement of millions. The accused saw the scale of suffering was enormous and met representatives of the primary victim nations at international conferences. The victims begged not to be killed, some using the words, "This is a death sentence for my people." The accused then saw the pace and scale of harm increase and were warned that death and suffering would be unprecedented. They also saw that the process of annihilating low-lying island states was accelerating, and the number of nations to be destroyed depended upon them stopping their policies. But the accused continued to expand some polluting activities and refused to decarbonise other sectors of the economy as quickly as they could. The accused did not necessarily hate the victims, but the accused knew they could not achieve their personal, national, financial, economic objectives without the harms occurring. The suffering, death and destruction was a necessary and unavoidable consequence of their policies. When the Met Police received the case, they dismissed it out of hand, saying that there had to be intent to commit the crimes for there to be any prospect of a successful conviction. It was clear that the Met was only referring to direct intent, ignoring the provisions that allowed for a prosecution in cases of oblique intent. When we challenged the Met on this, it categorically refused to explain its thinking. Throughout early 2020, we pressed the Met repeatedly, but it would not explain its thinking around Article 32B. We appealed to the Independent Office for Police Conduct, which refused to even consider a complaint. We appealed to the Mayor's Office for Policing and Crime, which refused to deal with the substance of our complaint. It adopted the attitude that if the police received a request for a criminal investigation, it decided it would not pursue it, and that was a matter for the police. We even approached the Crown Prosecution Service, warning of a miscarriage of justice, but the CPS said the decision not to investigate was entirely a matter for the Met. We formed the opinion that the Met wouldn't investigate because they either wanted to protect the most senior politicians in the country or feared for their careers if they did mount an investigation.
Having exhausted all options within the UK jurisdiction, we were then at liberty to take the case to the International Criminal Court, the ICC. We referred our case to the ICC in 2021, but it moved slowly. By the end of 2021, it was clear that the ICC accepted that the oblique intent provisions written into the legislation weren't an obstacle, but it raised a technical point about its jurisdiction. There were other cases being referred to the ICC from other countries, and it seems that the technical point relating to jurisdiction has now been overcome. However, CGAN wanted to press the UK authorities to act, and in 2022 we found a way to do it. Two things happened.
More and more people were undertaking disruptive climate protests, which resulted in trials. During those trials, judges would tell people that you had no right to take the law into your own hands. The judges told protesters that no one is above the law applies to all. So CGAN wrote to the judges that heard climate protest cases and explained that this wasn't true. The police were determined to protect senior politicians from legislation enacted by Parliament.
So the second thing that happened was a new Metropolitan Police Commissioner was appointed who declared he would serve without fear or favour, looking into any corruption. Several things had gone very badly for the Met, and he declared that he would break from the past, stamping down on all corruption. So CGAN submitted a further dossier of evidence to him in September 2022.
At first, the Met Police again tried to dodge the case, but it seems judges were asking the Met what was going on. In January 2023, the Met told CGAN that a detailed explanation would be issued, and that arrived from the Met's lawyers 3 months later. The Met's Directorate of Legal Services responded in more detail than ever before, but their thinking was flawed. CGAN quickly replied. A month later, another letter arrived from the Directorate of Legal Services. CGAN again replied promptly, pointing out where the further errors were. The Directorate of Legal Services had made some very simplistic errors. For example, it hadn't read the dossier of evidence carefully. It made incorrect assumptions about the number of people being killed or harmed by climate breakdown. It believed the numbers were low, and it was impossible to attribute UK responsibility to the deaths. We explained that the numbers are huge and growing. We refer to the 33 million people impacted by record-breaking floods in Pakistan and the 140 million impacted by the record-breaking drought in the Horn of Africa. We refer to IPCC evidence that 3.3 billion to 3.6 billion people live in contexts that are highly vulnerable to climate change. We refer to damage to crops, to property, to mass displacement, and to evidence that showed 400,000 people are being killed by climate breakdown every year. We showed that the UK only had 0.85% of the global population, but it was responsible for 4.52% of direct historical emissions, with the UK's financial sector being responsible for even greater emissions elsewhere. We showed that international criminal law did not require that a politician take food from a victim and wait for them to starve to death. The attribution of responsibility and causation was different. We carefully set out the process from decision by a politician to the outcome, mass death and suffering. We also explained that UK politicians do not act alone. They were acting in tandem with other politicians in other countries who sought similar benefits to the UK, despite knowing those benefits directly lead to mass suffering and death. The Directorate cited a legal precedent associated with the application of Article 32B. That precedent showed that there had to be a very high degree of certainty that a policy decision would result in mass death or suffering. We explained why the Directorate's thinking was incorrect, explaining the degree of certainty with the science. We showed that the accused politicians knew with absolute scientific certainty that the policies they pursued would cause the harms listed in the legislation, and if they did not stop their policies, the death, suffering and destruction of low-lying islands would accelerate. We had asked the Directorate to seek professional advice from the International Criminal Court, but it was telling that it refused to do so. We put it to the Directorate that this must surely be because the Directorate knew it would be overruled. The Directorate also made reference in 3 places to a concern that it was not for the Metropolitan Police to change the policies of a democratically elected government. We explained that the Met does not have any such obligation to individual elected politicians. The Met's obligations are to Parliament. Parliament is the body that makes the laws applicable to everyone in the UK, and it is not for the Met to pick and choose which laws it will enforce and which it will not. The exchange of correspondence with the Met's lawyers was devastating. We had proven there was no lawful basis for the Met's refusal to mount a criminal investigation back in 2019. We called upon the Met Police to now begin a criminal investigation and ensure the highest possible standards of professionalism and integrity by those asked to undertake the task.
As this video was filmed, the Met's lawyers are considering their position. What is clear is that the Seagan case is robust, and the oblique intent provision in Article 30 of the Rome Statute can be used in relation to prosecuting policies that drive climate breakdown, causing mass death and suffering. Individual politicians and business people can be prosecuted for crimes against humanity and genocide and the complete annihilation of several low-lying island states. Every nation that is a signatory to the Rome Statute can use this legislation to stop key climate criminals. So, if you have a contact with a campaign group in Germany, France, Italy, or any one of 123 nations, ask them to seek a criminal investigation by their own police.
If you have undertaken a disruptive climate protest and faced trial, please get in touch with Seagan, which will provide you with a witness statement you can use in court. The key point judges need to consider is that, had the police acted in 2019 to stop the killers, none of the climate protests since January 2020 would have happened. If the politicians had been forced to stop killing, none of us would have been protesting. Judges are left with a very uncomfortable reality. We have a corrupt criminal justice system that protects those who kill and prosecutes those trying to stop the killers. and that position was only possible because the police had perverted the course of justice by refusing to act upon legislation enacted by Parliament.
The time when climate criminals are stopped from killing has just got a little closer.